So first, so let's start with this forum. Well, first, let me welcome you to the third SCLA Global Online Forum, which is the Chinese-Swiss International Sports Arbitration Online Forum. And first, I would like to wish you or your family and you stay in good health during this pandemic. And me and SCLA are working on both in the donations, continuous donations for the Global Fund and for other institutions to work for fighting with the coronavirus. And please let me know if I can do anything help in China. Currently, I'm also in self-quarantine in China because I just traveled from Europe. I have been a week left. So, so on February 28th, 2020, the Court of Arbitration for Sports announced the arbitration result of the previous World Anti-Doping Agency. The Chinese swimmer Sun Yang will be suspended for 8 years. Today, we are not only going to discuss this case, but also going to exchange exchange and explore the laws behind the case, which is the sports arbitration. And please let me welcome all the speakers and all of your participants from over 11 countries and regions, which are China, Hong Kong Special Administrative Region, Switzerland, Sweden, United Kingdom, Germany, France, United States, Bangladesh, and Netherlands. And the tradition of SCLA Global Webinar is to be interactive, meaning that you are extremely welcome to introduce yourself, bringing your idea and questions at any time. And during the presentations, please use the chat functions to type your question in the chat box, which you can press Alt+H. You can find the chat box. And you are more than welcome to share the documents to all participants in the chat box as well by uploading the files. So first, let me introduce what is SCLA, what is the Swiss Chinese Law Association, and very briefly. So the values of the SCLA is to become a global community, a global platform, and a global voice for European, particularly Swiss and Asian, particularly Chinese lawyers. So the values of the SCLA is the connections. The connections will be coming twofold. First, it locates in Geneva, Switzerland. We are going to connect it and promote a legal collaboration among China, Switzerland, and European countries. The second fold of these connections of this value means that Swiss Chinese Law Association also promotes the connections with the international organizations. And for example, SCLA has been applying for the observer status of the United Nations Conference for Trade and Development, which will have more evolved engagement in the decision-making process, and it will be approved in 2021. So the visions of SCLA is to have twofold as well. So one, as I said, as a global voice for legal, one is we hope these connections will bring a more transparent, integrated global legal market by reducing the transactional costs between Europeans and the Asian countries, so that an open platform, rather we having a closed cycle, and we have the member lead actions, and which we can enable, make it possible to connect with each other and to make it as a global platform. And the second is we hope to become a global voice for the legal communities in the decision-making process, international decision-making process. For example, we have been engaged in a lot of conference and policy-making process within the United Nations. So what is the figures of SCLA? So since its establishment, SCLA has established one friendship with a lot of institutions. It's a young association, but it's developed in a quite well way, and we have a lot of member lead actions. So we have over 90 members from 6 different countries across different sectors, including law firms from different sectors, such as also the judicial sectors and private companies. And we have also not 5, I think now it's 10 members from different international organizations, including myself. I have been working for the United Nations for the International Law Commission as a consultant. So the actions, what does SCLA do? So firstly is we promote a kind of common standard of legal practice, so that to promote a more reliable and trustworthy a more transparent legal market in different sectors, and it is completely open. It is completely, let's say, members driven. This project, we are starting to negotiate to discuss what is like some values that both Chinese and Swiss lawyers are jointly recognized. And the second is the global presence. As I said, we are applying for the observer status of UNCTAD. And thirdly is a new project which we started 2 weeks ago with regarding the launch the Center of Proof of Foreign Law. So this project is also with Professor Yibo is also joining with us today. So you are more welcome to discuss with him and later, and welcome him to share some ideas in the chat box as well. So the Center of Proof of Foreign Law, it will be established in Nanjing City, which is a very nice city located in the Jiangsu province. So it will not enable the Chinese institutions, courts, and law firms to find out the foreign law impartially with reduced cost, but it will facilitate academic research between education institutions and professional institutions. So it's jointly held with Nanjing City Municipality and Southeast University. And we are welcome for lawyers in the law firms to join these initiatives. Let's say how we can work, how we can go further to make China to connect to the world, to understand more about foreign laws, because law itself is geographically restricted, right? So the lawyers within a certain country, the practice has the geographic boundary. So why don't we connect to each other? And that is also the idea why we have the Center of Proof of Foreign Law. And also the last one is the Swiss Chinese Law Review. We are currently led by a colleague working in the coronavirus issue. So this is the locations. We provide great coffee and delicious food for your visit and for free. If you are anytime welcome to join us for delicious Chinese food, by the way. So sorry for missing. So that is the about ourselves. So I have 3 minutes left. What I wish to do is I wish to go over this list so that people can introduce themselves in a quick way, and please could you introduce yourself in 1 or 2 sentences, who you are, where do you work, and in 10 seconds. So first on my list is Mr. Peter Flavio Peter, are you there?
Yes, I'm here. Can you hear me?
Yes.
Good. My name is Flavio Peter. I'm a counsel at Wenger and Vieli. We're a Zurich and Zug-based Swiss law firm, and I specialize in commercial arbitration. So I'm not as familiar with the sports arbitration world. That's why I'm joining today, and look forward to hear and learn a lot of new stuff.
Thank you very much. And Mr. Michael Walgreen, are you there, Mr. Michael? Maybe he's has not. He will join us maybe later. So next, Mr. Tan Yaowen. Hello, Mr. Tan. Okay, so so we'll come back later. So next one is Miss Victoria Tivenanvo. Sorry for my.
That's quite all right. I constantly get that. I'm Victoria Tivenanvo, joining you from the UK, from Denton's, and I work in the field of sport with the particular aspect of competition law. So less on anti-doping, but that's why I'm here as well. Find out more.
Okay. So next one is Mr. Wang Xiaoping from China. Are you there, Mr. Xiaoping?
Yes. My name is Wang Xiaoping. I'm a partner of the Grand Law firm in China. I'm located in Beijing. My specific field is international investment, international trade, and also the intellectual property and financing. Eventually, I'm just have been the Lausanne last January. I eventually help in the Olympic Museum there. Anyway,
Okay.
I'm a little bit, interested in such sports arbitration. Eventually, I'm in charge of some litigation and arbitration, but not yet in the sports arbitration.
Thank you very much, Mr. Xiaoping.
Yes.
And we will stop here, and we'll come back to introduce ourselves in the break. So please let me firstly welcome Mr. Wu Ming, partner at Zhonglen Law Firm Shanghai office. He will bring up a discussion regarding the case brief and insights from a Chinese perspective about the Sun Yang case. Mr. Wu Ming specializes in international commercial arbitration and international sports arbitration. Mr. Wu Ming is one of the few Chinese lawyers who have practical experience in sports arbitration before FIFA, Dispute Resolution Committee, Basketball Arbitral Tribunal, and Court of Arbitration Sports. So time is yours, Mr. Wu Ming.
Okay, thanks, Mr. Zhang. My name is Wu Ming, a partner at Zhonglen Law Firm Shanghai office. And today, thanks Swiss Chinese Law Association for organizing this fantastic event. And let me share my point of view on the case WADA versus Sun Yang and FINA. Before class, I wish this event a great success. So I'm gonna share my PPT with. Okay, now you can see that's my PowerPoint. So the topic of my speech today is about the case brief and insight from a Chinese lawyer's perspective. Okay, so today I will have around 10 minutes to give my speech, which will be split into two parts. Part one will be I will brief this case and introducing the factual background and focus of dispute, and part two I will share my thoughts on this case, like what kind of lessons we can learn from this case. Okay, so now let's look back. What happened in 2014? Okay, according to the athlete, because of an issue with his heart, he would faint after some training sections. So in 2014, the athlete's doctor made a mistake and prescribed him a banned substance to treat that issue. Okay, and as an consequence, so the athlete tested doping positive, and as a result, he received a 3 months period of ineligibility. So apparently that athlete already committed his first anti-doping rule violation in 2014. And does it matter? Yes, because according to the FINA doping control rules, if an athlete commits his second anti-doping rule violation, then the period of ineligibility will be doubled, which means a 4-year period of ineligibility will become 8-year ban. So, and as a rule, the arbitral panel has no discretion in this issue. Okay, and then we move to the event of 4th September 2018. What happened on that evening? So on the evening of 4th September 2018, you can see that FINA authorized the IDTM to collect blood and urine samples from the athlete. So this was an out of competition sample collection mission. So 3 persons from IDTM carried out the mission. They are a female doping control officer, we call it DCO, a female blood collection assistant, BCA, and a male doping control assistant, DCA. So in the beginning, the athlete signed the doping control form and cooperate in providing 2 blood samples. So these samples were sealed in a glass containers and stored in the storage box. Shortly thereafter, the athlete discovered that the DCA had taken pictures of him. So the athlete asked to check the credential of the DCA, and then found that both the DCA and the BCA did not have individual authorization letter from either FINA or IDTM. So then the athlete demanded to remove the blood samples. The DCO took the glass containers from the storage box and handed them to the athlete. The athlete assisted a security guard to break the glass container and took the blood vessel out. The blood vessel remained intact, but was kept by the athlete. The athlete also tore the doping control form that he had previously signed. So that is the very brief factual background of this case. And then we look at the argument on the interpretation of Article 5.3.3 of the International Standard of Testing and Investigations. Okay. So now, how to interpret this article is the most important issue of this case. But unfortunately, CARS disagreed with the athlete's interpretation on this article and concluded that a generic letter of authority issued by FINA to IDTM is sufficient. And so the DCO, DCA, and BCA did not require a specific and individual authorization letter mentioning their names individually. And CAS also found that the DCO at that night had already given warning about the consequences of a failure to comply to the athlete, though the athlete might not have paid attention to that warning. Okay? Then, so finally, the CAS conclusion is that the athlete hadn't had a compelling justification to fail to comply with the sample collection process, and consequently violated Article 2.5 of FINA doping control rules, which is a tempering violation. Okay. So as this is the second violation, because we just mentioned in 2014, the athlete committed his first violation. So this is the second violation. So the athlete was banned for 8 years. Okay. So as a high profile case, people have lots of discussion on it. So as a Chinese lawyer, I'd like to share my thoughts on what we as a whole can learn from this case very generally. First, it's for the athlete. Okay? So it's prudent that the athlete complies with the direction of a doping control officer and provides samples in every case. So if the athlete has any objection to the entire process, he or she can still, cooperate to conduct the sample collection and under protest by recording his objection, complaints, or any comments on the doping control form or through any other methods. Okay, this is the thoughts for athlete. And for China Anti-Doping Agency, I think, Canada promotes the culture of zero tolerance with anti-doping violations. Okay, as we can see in this, aspect, there is much space to improve with Canada. And for Chinese witness before International Arbitral Tribunal, so my thought is, or advice is that, because we can see the performance of Chinese witnesses in close examination in this case can be said as a nightmare. But I would not blame the witnesses. On the contrary, as a Chinese lawyer, I can understand why their performance was so bad. The reasons include culture difference, the way Eastern people defending themselves are different from the way that people, Western people, and not familiar with the adversarial trial process, like accusing and defending, etc. So therefore, the preparation and the practice are very important for Chinese witness. So for example, the witness must be very familiar with his or her written testimony previously submitted to the arbitral panel. So when he or she answers questions, he or she should stick to his or her testimony. So otherwise, his or her credibility will be impaired. So that's the thing happened to those Chinese witnesses in this case. And we also look at the Chinese media. This case has caught massive attention of Chinese media. When we look back, what happened with Chinese media in the past 1.5 years, we can see that a 180-degree reverse as to media's attitude toward the athlete on or after 4th March 2020, the day on which the CAS released its full decision document on this case. So the reason I think is that because it's for the first time that the Chinese media had a chance to read a different version of a story from a party besides the athlete. Okay, so there is I think there is much space to improve, as to the professionality of Chinese sport media. And finally, we go to the topic of the globalization of Chinese sports industry. I believe that a positive effect of this high-profile case is that it will definitely enhance people's awareness of and speed up the globalization of Chinese sport industry. So at first, people will take this opportunity to introspect how we deal with sports rules, including laws of game, disciplinary code, anti-doping rules, and even the procedural rules of sports arbitration. But do we really understand these rules? Without doubt, only after we can interpret the rules precisely and confidently, then we can utilize these rules to gain and protect our interests. So the second aspect of the globalization is of a sports industry. It's about the business mode and the market scale. We will need to learn how to operate and manage the sport intellectual property. For example, in 2014, NBA signed a 9-year television sport broadcasting contract with 3 American national TV networks, which is ABC, ESPN, and TNT, at a price up to $24 billion US. So NBA is paid $2.7 billion annually for its TV broadcasting. So as a comparison, CBA can only get $50 million US a year from its TV broadcasting deal. So the TV broadcasting price difference between NBA and CBA reaches 54 times. So you can see there's a long way to go. Okay, that's what I like to share with you today, the factual background, focus of the dispute, and some thoughts on this case. Thank you again for Swiss and Chinese Law Association, and thanks for you guys spend time to listen to me. Thank you.
Thank you, Mr. Wu. Mr. Peter asked, could you quickly elaborate who were the witnesses when hearing this case?
You asking me?
Yes.
Okay. The witness, the number one witness is the athlete, because the athlete, in the international sport arbitration, he can at the same time he can be an witness. So he's the number one witness. And the second one is his doctor, Mr. Ba Zhen, should, I think, take the responsibility for the athletes' first doping rule violation. And the third witness is a leader of the Chinese swimming team, the national swimming team. Is a leader he is the person that that night the athlete called to. And the fourth witness is the deputy leader, or is someone that who in charge of the Zhejiang province anti-doping agency. So he is at that night the athlete, and Mr. Ba, Dr. Ba also called to the witness, the fourth witness, for asking for his opinion on what the rule, the anti-doping rule, should be interpreted. And the fifth witness of the athlete is Shen Yang's mother, and the last one witness is an expert on China law, Professor Pei Yang. So that's the witness of the athlete, and in this case.
Sorry, if I may quickly ask, I understood you saying that those witnesses testified and they malperformed, in a sense they did not perform very good in front of the tribunal. Did I understand you correctly?
Yes, you are correct. Okay. That's what I'm talking about.
That's why I was asking. I wasn't quite sure who the witnesses were. I understand. Thank you.
Thank you.
And thank you, Mr. Wu Ming. And can you explain why there was a change in the Chinese media? What do you think that, and before release judgment and after the release of judgment, why there was a radical change regarding the athlete?
I think that is a topic that is very sensitive, in China. Actually, people don't want to, talk too much about that. Criticizing the professional ability of the Chinese sport media. They done their job very well. But when we're talking about specifically, on this case, last year I had I wrote 2 articles on this case, for talking about what will happen, in the cars trial, what something like that, very professional analyze on this. But but from the perspective of the sports media, they only listen to what the athlete talking about, what the athlete's social media, what the athlete released on his social media, and the media, Chinese sport media trust, the athlete very much, and kind of, they do not want to, or they are unable to read, the materials from from English language or from different source. They rely on single source too much. So after 4 March, and they have the chance to read the 48 pages, the full decision, which disclose lots of facts, lots of arguments, lots of analysis, reasoning. So then they have the chance to sit down and think, what is the truth. I think that why they have a change, a very significant change.
Okay, great. Thank you, Mr. Wu Ming, and thank you for your introduction of the case. I think it's great to look back what was happening in last year, November. What was the what is the case, and it's great to know. And next, please let me allow me to welcome Ms. Cai Guo. She will discuss regarding what the Sun Yang case at the Court of Arbitration for Sport brings for the Chinese athlete. And Ms. Cai Guo is Cai Guo oversees Lex Veritas Sports and International Law Group, which is the Jimo law firm. The first Chinese law firm have a practice group dedicated to sports industry. And Ms. Tsai graduated from Harvard Law School and China University of Political Science and Law. She also held LM in Human Rights from the University of Hong Kong. Thank you very much.
Thanks, Tianze. Can you hear me?
Yes, yes.
Hi, everyone, and thank you for spending the time with us. Thanks for the Swiss-China Law Exchange or Association for organizing this forum. So I think it's worthwhile first for me to briefly introduce my background so that you could understand why I view the case in the way I saw it. Because I would like to focus more on the angle, because I think this Sun Yang case illustrates very well that sports law, sports arbitration it's a perfect convergence of international law, constitutional law, and human rights law. So I'm a Chinese lawyer specializing in sports and dispute resolution. A little exceptional in China because I think across Asia, you wouldn't find any law firm readily offers that are practice combining like sports or international law, but these are my passion. So I practiced from a leading Chinese law firm before I delving into sports. And I also worked in the international arbitration department of Sherman Sterling, where I focus on commercial arbitration and also investment arbitration. So what was the relationship with this experience with what I do now? So I think I started to do sports since 2016 when there was the Rio Olympics. And I find that I carved my own path actually to combine my passion with my practical experience. And I was amazed to find that the sports was a perfect convergence of all this international law and constitutional analysis. Why do I say that? Because I think sports is just inherently very international, because to make international competition to happen, you must, all the participants from across the globe has to observe and follow a set of harmonized and uniform rules. And also there will be international organizations like FINA or FIFA or IOC and WADA. They are going to draft these rules and also enforce these rules. And you will have the CAS as the final adjudicator of most of these disputes. So it's just international. And if you have this sports governing bodies in play, then there will be inevitably constitutional issue because they govern through their statutes, this federation's constitution. And it's just part of the sports governance and sports pyramids that there will be disciplinary proceedings and including the anti-doping proceeding that that the athlete is brought in front of this sports governing body. And usually, I think the final argument for an athlete is to challenge the rules themselves, that they are unfair, they are violated fundamental human rights. So so if they can prove like certain rules violated fundamental human rights, or a set of like a mandatory public international law, then there will be higher chance for them to overturn these rules. So constitutional analysis and constitutional thinking are quite helpful in terms of this sports disputes. And finally, you would say like human rights law really come into play. And I think in Sun Yang case, his lawyer also indicated that he will fight all the way to European Court of Human Rights, which I think will be very exceptional for a Chinese athlete, because it would be the first time, I believe, for a Chinese national to engage in international proceedings to protect his human rights. Because I think China has not joined the ICCPR, and of course we are not part of the ECHR, but then probably, you know, we will see a Chinese athlete actively engaging in this proceeding. So that's quite exceptional in my way. So you see, like this is really, so I find like my passion really worked very well and converge in my working in sports. So when I analyze the Sun Yang case, I always find that it's perfectly illustrates these three areas. And I think if you are familiar with just the international law or constitutional analysis or human rights, you will actually find it very comfortable to follow the reasoning of the CAS panel, because it's just a very standard reasoning, nothing nothing strange or odd. But what I see from China, from Chinese legal profession, and or even the defense team of the athlete himself, you can find that they raise a lot of questions about this procedure. And I think the reason why they raise these questions exactly because they didn't put the CAS procedure in the context of international and sports specific context. So I can give you some example of those questions. So question number one, these are, I will list like 4 questions that you commonly see in China, and some are even raised by some professor or legal professional. So these are the questions. So question number 1 is that, this case is just totally unfair because WADA is the rule drafter, is a rule drafter and the prosecutor at the same time. So the two parties, Sun Yang and WADA, are never on the same level playing field. Well, this sounds very reasonable because WADA is the rule maker, and then now it's going after Sun Yang. But if you work in sports, then you will find it very natural because this is just the part of sports governance, and this is just the nature of the disciplinary proceeding, and it's existing in every large international federation like FINA, FIFA. And also other organizations or IAAF, I would say. So you wouldn't find it very strange. And question number 2. So they say that the CAS panel chose to follow lower standards stipulated by the ISTI rather than the higher standard or the best practice adopted by CHINADA, which was more familiar to the athlete and his support staff. So it would be totally unfair that the CAS panel choose to kind of listen to those lower standards rather than the higher standard that was quite common in China. But then, is there any fairness problem here? Because it sounds, maybe yes, on the surface, but I would say totally not in substance, because I think everyone who has a little bit experience in international law would agree that it's, the signatories are just bound by those rules that they expressly accede to. So that's mandatory rules, that's the ISTI rules and WADA code. But then there are also a lot of rules which are not mandatory at all, and they just embody good intention or aspiration that haven't escalated to the status of mandatory rules. So yeah, so it's no question here. And question 3, what is question 3? So they say, okay, it's universally accepted the custom practice that where there is any ambiguity in any rules, then the adjudicator must interpret it in a way unfavorable to the rule maker. So here is the WADA. So this also was raised by a lot of people, but then I think they ignore the fact that there's no ambiguity in the rules, at least as found by the CAS panel. So they made it very clear that Article 533 of ISTI has no ambiguity. So it's just a very clear rules, straightforward. And question number 4. Question number 4 is a bit Chinese specific, because I think the athlete and also even after the hearing, his team continue to argue that the blood control assistant, that was a nurse in this case, the BCA, she was alleged to have violated Chinese law because she allegedly drew blood from Sun Yang in Hangzhou, which is a different city from Shanghai, where she's registered as a practicing nurse. So they kept saying, hey, she's violating Chinese law, so there must be kind of procedural flaw in this case. And then Sun Yang will have this compelling justification to suspend the doping test. But then I think there are two questions that need to be asked. The first question is, that is really drawing blood, is the nursing. Is this a kind of nursing? And the second thing is, even if we take a step back and accept that, drawing blood is also a type of nursing, then is it kind of drawing blood in a different region that you're not registered with, a flaw serious enough that invalidates the whole session? So I think these are valid questions to be asked and needs to be answered by people who hold those views. So you see, like a lot of international law issues and human rights law issues, and also constitutional law issues arise in this case. And I think they also brought human rights law arguments at the end of the hearing, because I think the FINA Council raised very briefly that they say the ISTI and WADA code was in compliance with the Swiss law and the public policy, but it was raised very briefly, and I have no idea how much reliance they put on these points. Well, so these are the questions that you would see quite common in China. And these are not just from the common observer, they are from sophisticated legal professional. And it actually largely echoed with the strategy of the athletes defense team as well. But if you follow the hearing at the CAS, you will actually find out that these line of arguments largely miss the target, unfortunately. Because for most of the time, I think the athlete didn't argue on the same page with the WADA side and also with the panel as well. And so it doesn't help him. So why does this defense strategy unfold in the way we saw? My reflection was because I think they were not understood. This issue, which is quite highly international and sports specific, was not understood in the international sporting context. But in the fields of sports, you would say like a lot of rules working locally doesn't apply across the globe. But it was international federations and also WADA who were exercising jurisdiction in the field of sports. So you have to kind of have this sense of international analysis. And if we look into the Sun Yang case and analyze the trajectory of why these bizarre incidents happen, you will find actually the incidents arose and the dispute arose exactly because someone who advised him and someone he heavily relied on actually confused China requirements with ISTI mandates. So yeah, so I'm going to finish very soon, and at the end of it, I would like to just share my screen. To list 4 questions I prepared for my Swiss colleague in relation to this law, in relation to this case. So the first one is, what is the possible consideration for Swiss lawyers behind those multiple challenges against WADA arbitrator and counsel? Because we are lawyers and we understand that all these challenges were actually without merits. So what are these considerations behind those challenges? And my second question is, because we say in this case, issues arise concerning witness compelling and witness protection, because WADA here, he wrote like for 6 times to CAS and requesting protection for the witnesses. But I'm not sure whether CAS really has any effective mechanism to protect this witness. So in your view, under Swiss law, what would be the effective witness protection mechanism? And if you want to compel a witness, maybe residing in China, to testify in front of CAS or federal tribunal, what could we do? And the third question is to better streamline, how to better streamline the coordination between the Chinese counsel and the Swiss counsel. Because in this case, I think there is a disconnection between the Swiss colleague and the Chinese colleague. Because in the translation issue, I think the Swiss lawyer in the hearing indicated that he was not aware that the translator was very bad. And he was not aware that the athlete actually waved somebody from the bench to join him. So he was taken aback, and I think it's not good for coordination if the information was not transparent between the co-counsel. And the second issue here is the harassment of the WADA witness, and I don't think like he and I do not think like the Swiss lawyer knew about it. And the last question is quite technical. Is in the SFT, the Swiss Federal Tribunal proceeding, FINA was actually taking side with the athlete, but it was listed as a co-respondent with the WADA. So I was quite curious about this. So my time is up, and thank you for your patience, and I'm really looking forward to hearing all the insights from all of you, and thank you very much.
Thank you very much, Ms. Tai. Just a very small question I want to ask is like, you know, all of these associations, like all the almost FIFA and WADA and including IOC, they are based in Switzerland. They are subject to the Swiss law. You know, they in a substantive way they are subject to the Swiss law governance. Do you think like is it fair, like, or to say, how do you think, like, is it accessible for as a Chinese lawyer or as a lawyer from other countries to know the Swiss law, and how does the system works? How do you think about that?
Well, it's a very interesting question, actually, but my position was always saying, so before the rules has changed, you have to accept it as a status quo. So now the status quo is that all the federations were in Switzerland, and the Swiss lawyer, they are more actively involved in those proceedings, and a lot of these proceedings involving sport require Swiss law specific knowledge. So lawyers around the world usually need to collaborate closely with our Swiss colleague. Yeah, so exactly that's, I think, what happened in Sun Yang case as well. I think a lot of people, or Sun Yang himself, was questioning how fair it was. But I think, but right now, when you have, for example, committed anti-doping violation or was an alleged one, I don't think like you just raise the objection afterwards. I think when the rules were like that, you have to follow it. But then I think it's interesting to note the athlete never questioned, or his team never questioned, hey, Sun Yang is a Chinese athlete, but why does he go to Switzerland for 2 times to kind of defend himself? So that's the way it is. But then I think it's there are certainly ways for Chinese lawyer and also lawyer from other jurisdiction to train ourselves to be better versed with international sports law. For example, I think we are advocating for establishing internal dispute resolution in the Chinese association, sports association, and maybe establish a Chinese sports arbitration institution, so that I think our athletes will have rules and also due process to protect them once they have any dispute with their governing body, and then we as Chinese lawyer will have more training opportunity to be more familiar with the procedures.
Thank you very much, Ms. Tai, and it's great to we get now from the Chinese side of how was the idea of these cases, what was the media reactions, and how was the different opinions from side, and how do people, or like say representative Chinese lawyers, think about the CAS. So now let's give our stage to our Swiss colleagues with Mr. Philippe Vladimir Boss. He's going to discussing in the anti-doping environment mapping, and who was the players and stakeholders. And Mr. Philip Vladimir Boss is partner at Bianchi Ward, and he was a former clerk at the Federal Criminal Court of Switzerland. His practice areas including money laundering, bribery, and fraud cases. Mr. Philip Vladimir Boss advises and appears before various jurisdictions in sports-related matters. He specifically advises international federations and officials in sports integrity issues. Now, time is yours, Mr. Philip.
Try to share my screen, if I may.
Yes, please.
How can I do that? Oh, yes, here it is. Yes. So, thank you very much. My name is Philippe Boss. I'm a Swiss-based lawyer in Lausanne. I'm in my office today, even though usually I work from home, but today I'm in my office. Thank you very much for the introduction. As you said, originally a criminal lawyer, I also assist international federations in the field of sports, mainly those based in Lausanne, mostly in disciplinary cases or in matters of contracts. And I also appeared very often in front of the Swiss Federal Tribunal after CAS awards. So as we have had very interesting remarks from our Chinese colleagues, you will have seen that many different entities are named, and the idea of my introduction, before I give the floor to my Swiss estimated colleagues Valloni and Moran, who will get into more details, was that I would give just a mapping of the different stakeholders and just give a bit of a who's who, which might be helpful for you. Of course, I understand that we have a different expertise in the field of sports. For some of you, this presentation will be very basic. For others, I hope it is helpful. So basically, yeah. Yes. So I will, as I said, make a mapping of those stakeholders, and straight after that, always make a direct reference to the Sun Yang case so that we can place each of those stakeholders both generally and specifically in the Sun Yang case, which is an award which you can find if you're interested on the website of the Court of Arbitration for Sports. So starting now with WADA and the WADA code. So WADA, the World Anti-Doping Agency, based in Lausanne, but with headquarters in Canada, in Montreal. It might be useful to say that it is based on the cooperation, let's say, of both governments on the one hand, but also the Olympic movement, which makes that they both together represent the World Anti-Doping Agency, each of them through different bodies in a rather complex structure, but each of them with 18 members. They together form the foundation board of the World Anti-Doping Agency, which you can see is based on the WADA statutes. All those references in blue are, of course, those you can click on and find the example on the internet. So this is something you see in the Sun Yang case. It clearly says that WADA's aim is to promote and coordinate the fight against doping in sports internationally. So WADA's aim is not to enforce it at first. The task to enforce the World Anti-Doping Code at first lies on other bodies, but of course WADA will be there to have a global coordination and enforce it in the last resort where necessary, and which is what happened in the Sun Yang case. So, for example, going back to how WADA is representative of the sports world as regards the Olympic movement itself brings its 18 members through different bodies, which are, well, sorry for very barbaric acronyms for those of you that are not familiar with them. but IOF, which is the Association of the Winter Sports Federation at the Olympic Games, ENOC, which is the Association of the National Olympic Committees, ASWAF, which is the Association of the Summer Olympic International Federations, GAIS, which is another association of international sports, but not limited to Olympic sports, the IOC Athletes Commission, which is where athletes would have more impact on WADA and its structure, the IOC itself, of course, and the IPC, which is the International Paralympic Committee. So all those entities will then, through their own internal representations and elections, bring those individuals to the foundation board, which will then give some representation to the very vast and diverse sporting world or Olympic movement, let's say. So this is a bit to give the idea of how representative WADA is. This is just a tiny note on the budget. In 2018, WADA had a $35 million budget, and you will see that it's equally sourced by both the public authorities and the Olympic movement. So WADA is responsible for enacting a series of documents, which we will see here. Of course, the WADA code. This is the first document, which is the first and more important document to talk about. Upon a broad consultation, it is not here that we will discuss how those documents are enacted, but it requires all those stakeholders that we mentioned before to be integrated in the consultation towards the enactment of those of the WADA code. And then the international standards. We will see one of those, which is very important in the Sunyang case, but those international standards are more practical rules that are meant to understand and implement the WADA code, such as the International Standard for Testing and Investigations, called ISTI, which is the one that will be discussed and was a debate in the Sunyang case, but also other international standards, such as the IS for Results Management, the IS for Therapeutic Use Exemptions, TUE, which is those procedures where an athlete can request to be exempted from any violation in case he takes some specific drugs for medical reasons mainly. The International Standard for the Protection of Privacy and Personal Information, this is data protection. Another standard for education, a standard for code compliance for signatories. This is very relevant in the Russian saga, where we see whether or not a signatory, so for example, a national anti-doping agency, is compliant with the code or not. And as well, the international standards on the prohibited list, which will list all the drugs that are being prohibited. And WADA also enacts guidelines, which are recommended practices, and we'll see in the Sunyang case that this was also discussed. As we mentioned before, the WADA code has some specific signatories. So entities that sign the WADA code and that are bound to enforce it, which is of course WADA itself, the IOC, so the International Olympic Committee, which will be in charge of doing the testing during or on the occasion of the Olympic Games, but also the international federations, the International Paralympic Committee, the National Olympic Committees themselves, Paralympic committees, major events organizers, and the national anti-doping agencies. So I put here Lionel Messi signing something, but he's not a signatory to the WADA code. So players themselves are not signatories to the WADA code. What the players come under the, let's say, jurisdiction of the World Anti-Doping Program, because whenever they enter a competition or whenever they are licensed by, for example, an international federation, then they commit to respect those rules governing anti-doping, but they are not directly signatories to the WADA code themselves. So these signatories that we mentioned, WADA, the IOC, the National Anti-Doping Agency, they must implement the WADA code through their own rules. So the WADA code is not directly enforceable in these cases. But to the contrary, the international standards are mandatory and directly applicable. So this is something we can see also in the Sun Yang case, where there was, on the one hand, the WADA code would not apply directly. It would be the FINA anti-doping regulation that would apply, which is, of course, a copy-paste of the WADA code. But then the ISTI, the International Standard on Testing and Investigation, which would be mandatory and directly applicable. This is what we find here as references to the Sun Yang case. So the number you see on the left is the number of the paragraph, which you can find if you look through this case. So the applicable regulation is the FINA doping code, which is, as I said, copy-paste of WADA, and the ISTI, which is for itself directly applicable. This is the paragraph of the ISTI, which was discussed before and which was highly debated in the case, whether or not they needed some more specific authorization, or whether those anti-doping officials or sample collection personnel could just rely on a more generic authorization. This was a debate, so you see that the ISTIs was directly applicable and debated. And here, sorry for the upper part does not have the number, but it's a part of the testimony of one of the witnesses, which was WADA's official, which said, and which was accepted by CAS, they say that the panel does not dispute Mr. Kemp's testimony and fully adheres to his logic that WADA's guidelines are not binding. So this is relevant, as we mentioned before, WADA code, international standards, guidelines. Those guidelines will help people understand how it works, but it's not binding source of law. So who tests who? That is also an interesting question, because as we saw before, there are many signatories, and we want to know who does what in these circumstances. So basically, in a very basic fashion, international federations will test international athletes, so those that participate to international competitions, and national anti-doping agencies will test national athletes. So in the FINA, in the Sun Yang case, of course, Mr. Sun Yang is an international athlete, reason why he was tested by FINA. Major event organizers will also test athletes that participate to its competitions, and WADA will test them in exceptional circumstances directly. This is where we come to WADA's role in such proceedings, and of course, as WADA was appealing the decision in the Sun Yang case, and the reason for that, I do not here rely or recall the mechanism that allows WADA to appeal in a deadline following the expiration of the deadline to appeal of the National Anti-Doping Agency itself. But you will understand that different stakeholders or different players can appeal a decision, and when they have decided to eventually not appeal, WADA still has a right to appeal, so that WADA can be sure to have a last word on every case, or at least to have a last call on every case, and bring the case to CAS if it considers that the decision made by, in this case, FINA, was not satisfactory in the present case. This is where you see here the reasoning of this cascade of appeal deadlines that Chiquinara could challenge the appeal decision at first, and that WADA could eventually decide it. And here it is interesting because CAS, or the CAS panel, explained the reason why it is reasonable to have this inequality, if you want, because our estimated Chinese colleague before mentioned that there was inequality between WADA and the athlete. And they say here in paragraph 176, where they say the special status and unique function of WADA serves it in the general interest to prevent and counter doping-related violations in sport. And in doing so, it pursues one of the key objectives of the Olympic Charter. And this is the reason why it has this right to appeal after the other stakeholders eventually decided not to. So who is involved in a process, in a doping process? A testing authority. So that authority or that body which is designed to test one specific athlete. Then a sample collection authority. In that case, there was IDTM, so a private company who is instructed by the testing authority to perform that testing. A result management authority, that can also be another entity or the same entity, depends on the cases. Then an arbitral tribunal, we see CAS, this is the case here, an appeal tribunal, the Swiss Federal Tribunal, even if appeal is probably improper in this case because it's a very limited power of review. ITA is another specific entity newly created and based in Lausanne also, who can be instructed by specific federations, especially to perform some or all of its tasks in anti-doping. So reference to the Sun case, sorry if it's pretty long, but it says that FINA had results management authority and authorized the mission as the testing authority. So FINA was the testing authority, and that the company IDTM was the sample collection authority. So you see that they are named differently, and that it eventually, that FINA formally asserted the violations. So FINA brought up the fact that there was a violation, and in consideration of all of that, CAS clearly found that FINA was the testing authority and IDTM was the sample collection authority working on behalf of FINA. Then the FINA doping panel issued a decision. This is also important because FINA was in charge of the results management. So when we speak of results management, it means who's in charge of taking the decision that would be appealed. And then the arbitral tribunal was CAS, and CAS found that it had jurisdiction to adjudicate this matter. Maybe a last word on the athlete, because he's also a stakeholder, even if it's not the signatory, he's directly interested at the issue of that. So what the athlete must do, first, the athlete must know the anti-doping rules. This is pretty tough because they are very complex and heavy. We might remember some cases where the athlete just did not know that, for example, a substance became prohibited at one point, a substance which he had used for many years. So it comes to very harsh situations. If we remember, for example, Maria Sharapova, who used some very basic medication for years and which suddenly became prohibited and was suspended for quite a long period. So it may be harsh sanctions just because of this, but this is the strict liability of the athlete. So he must know the rules. The athlete must be available for testing at all times. This is also quite a heavy requirement. And he must be responsible for any substance found in its samples, such as we said before, this represents the strict liability that he bears. And also the entourage of the athlete. So his team, his staff, his family, we have seen that this had an impact in the Sun case. The entourage may cause an anti-doping rule violation by the athlete. So they must take care of this. The athlete cannot just rely on them and say, well, it's not my fault, I was badly advised. Whatever bad advice he receives, he's responsible for it. And for example, in the Sun case, in respect of the athlete, first, the CAS says, well, the athlete is a world-class athlete with an impressive list of sporting achievements. He's not, however, above the law or legal process. The rules apply to him as they do to all athletes, and he's required to comply with them. So of course, if he's required to comply with them, he has to know them before that. And as regarding his entourage, is the principle that an athlete is responsible for his or her own actions and cannot deflect responsibility to his support staff, is a well-established CAS jurisprudence. And this is, for example, as our colleague before mentioned, the first anti-doping rule violation of Mr. Sun Yang, who was done on behalf of bad advice received by his doctor. Well, this is bad luck, but that's the situation he faces. He assumes the responsibility for the mistakes of his staff. So that's it. Thank you very much for your attention. I hope this did not go too fast. I saw that there was some maybe question. Or discussions, but I don't know if that was no, that was not related to this. So thank you very much for your attention.
Yeah, there is a question that why there is a increase in the budget, like in your slide, page number 7. There's a slide. There's an increase of the WADA's budget. Why it increased so significantly recently?
Let me just go back to it. You mean in which years?
Sorry, I think in the slides in the page 7 there is an increase. I mean, regarding the CAS, sorry, the WADA's budget. Why do you think that there was an increase? What was the?
So this budget was the budget was this was the 2018 figures. I don't have a specific explanation, but I wonder if this was. I wonder if it's just because the workload of WADA is expanding and they're doing more testing every year, or if it is related because they also had new bodies to fund, following especially the Russian case, because after the Russian case they had this new international standard for compliance for code signatories, and also the compliance committee, which had also a heavy load. So it might be related to this, but maybe others will have a more specific answer.
Yeah, and I have a question for regarding the international standard, or like ISTI, this kind of rules in different countries. We got participants like Ms. Kesnia from Russia, and for example, I don't know how does it work in Russia or in Sweden. Let's say Mr. Michael Walgren, can you comment that how was this international standards integrated in your country's anti-doping agency? For example, in Russia, I just heard the news in the last November that there was the national team was banned for the Olympics for a while, and also this year there are several athletes involved in the anti-doping agency. So how was it? How does the Russian or Russian lawyers think about the anti-doping rules provided by the WADA and the procedures like ISTI something? Are you there, Ms. Kesenia? Okay. Okay, so how about in Sweden? So
yes, in Sweden, this is not my core area, but I mean, Sweden has worked on this for a long time, and as we do with most of these rules, they are implemented quite by the word. I mean, this is really in all instances when we are signing on to some kind of regulations, they are immediately, to say, incorporated into the rules, and this should be the same case here.
Okay. Thank you very much. Is there any further questions? Okay, great. So
yes, Jean-Pierre. So Tang, I mean, just an observation on the budget for Mr. Following the intervention of Mr. Boss.
Yeah, great.
It is clear that one very important aspect of the budget was the the increase of the investigation cost following the Russian cases, and they WADA built up a full and independent, I mean, structurally independent investigation department, and they were really fully busy during the last years. They appointed a former Interpol inspector, in Mr. Günther. I have a blank on his name, but I mean, he was one of the 3 experts on the first on the IC Commission, and then he moved to head the investigation department of WADA, and they are doing. They have a massive operational job to conduct.
Thank you. We got a question from Mr. Shen Chang. Can you explain your question? What does? Can you explain your question a little bit? Hello, Ms. Shen Chang. You have a question. Does the term DCOs in the ISTI 5.33 refers to the DCO only, or it includes BCA or DCA? What is this question? How could you explain a little bit?
Yeah, I want to know whether the terminology DCOS refer to a collective team, or just refer to one person DCO, including BCA and the DCA. This is a terminology very special in this case. So I want to know what's the true meaning of this terminology.
Thank you very much. We can leave someone who can answer it, and they can type it in the box. So so we can move on. If anyone can answer this question, please type in the box, and we feel free to chat here. So let's move to the from the anti-doping. We have some we are mapping. We have from the cases. We know the cases, and then how was the stakeholders in these cases. Now let's move to the international sports arbitration. I mean, how does this international sports arbitration works? How was the rules behind the CAS? What was the players and why and how the CAS? What kind of institution is like CAS, and what alternative institutions beside CAS to do the sports arbitration? And let me welcome Mr. Lucien Valloni. Dr. Lucien Valloni is highly experienced litigating in both international and domestic criminal, commercial, and arbitration cases in Swiss courts, up to Swiss Federal Supreme Court level. Lucien Valloni is well known for his exercise in the field of appealing arbitration awards to the Swiss Federal Supreme Court, especially in sports arbitration. Lucien Valloni is also a partner at Zurich. And more important, he is also the writer of the sports law arbitration in Switzerland, which I got it last summer. It was really good. It has the 3rd edition now. It is very densely written regarding the sports law in Switzerland. So now floor is yours, Mr. Valloni.
Hello to everybody. I hope you can hear me and see me. Thank you for this Swiss Chinese Law Association and for the invitation to have a speech about this. I will talk about the following. I try now to bring in the topic. How is it? Where is it? Here. So, can you already see it? Can you see it? Is it okay?
Yes, it's perfect.
Okay, good. Introduction of international sports arbitration. The time is very short, so it can be only a little bit high level. But there are people who perhaps have never done sport arbitration before. That's the reason why I'm going on this high level. Now I will talk about 4 topics: settlement of sports-related disputes in sport, then the international courts of sports organization internationally in the federations, and then the sport arbitration and something about the Court of Arbitration for Sport. Now, if it is clear that if you want to run a sport federation, you also want to make sure that your rules are applied, and also especially disciplinary rules, you want to have them applied. And that is necessary. You need a certain power. And this power is coming from the state law, and national law is there different from country to country. But what we can say, a lot of organizations are based in Switzerland, and Switzerland does give a lot of power to any federation and any association. And this is protected even by the constitution. So, and this gives the right to set up rules and even to enforce them. Now, this gives also this law, this national law, gives the right to this international federation with seat in Switzerland, but in a lot of countries this would also be possible, that they can decide that certain internal bodies within a sport organization have a right to, let's say, put some decisions in respect of their of the application of their own rules. Normally, that are the disciplinary rules of the organization that are dealt with by an internal body. And this is clear that the national law gives some guidelines how such decisions can be taken. The first and most important point is that all these federations which have an internal decision-making process in place have to respect very, very basic principle of law, like the right to be heard and a fair hearing, and all these kind of important basic rules. And of course, what they have to respect is always their own statutes. That is very important. So they have to be measured by respecting their own statutes and regulations. So now, what is, if they have such a deciding body in their organization, as every international federation has, they have to, you have to follow first always the internal procedure. That means you have to bring the case to this internal federation deciding bodies, and if there is a second possibility to appeal the decision within the organization, you have to go first to this second instance. And only if you have taken all steps that the federation has provided for, you can think about other things. And that would be either you go to a state court, which is that was always the case before. In Switzerland, you can bring every case against any federation with a seat in Switzerland to the state court. But of course, the federations, they don't like that. And that is the reason why they have introduced an arbitration system. And this is possible according to Swiss law, because the Swiss law is very arbitration friendly. and it allows the federation to introduce such an arbitration system. And this was done by a lot of federations, the most of them, and this is done that the state courts do have very little to say in the end. And this gives the power to the arbitration court you refer to as a sport organization. And this has become a generalized principle now, a practice, and it is possible. But still, you could always, even if arbitration is agreed on, you could theoretically still go on to every state court. But of course, the other side, the federation, will then say, well, the state court is not competent anymore because there is an arbitration clause. That is something to think about. Then here, what was the idea of bringing sport arbitration into arbitration into the sport system? And it is different things are important. It should be quick, simple, and flexible in arbitration. Well, quick with the costs, it's not always the case, but still quicker than a state court. That is something we can say. So that is true then. And what is very important in sport, we have international federations that sets the rules for the whole world, for the whole sport applicable in the whole world. Now, if we allow state courts to decide on cases, then even if the rules are the same, every state court could come to a different interpretation of the rules, and this would bring no harmonization into the sports world. And that was one of the main reasons to have a sport arbitration put in place. And then there is another aspect. If we come back then to costs, there is a specialized judges on this list you can choose from, and this gives you a more chance to have somebody who understands the background of sport. And that is what the state courts sometimes have difficulties to see, because they do not often deal with sport cases. That was the idea. Now, in arbitration, as you probably know, it's not given from God. You cannot go to an arbitration court without having a clear arbitration clause. And in international sports, it's always the case that all these big federations, they put in place in their statutes a rule that you have to accept first the Court of Arbitration, that they do accept the Court of Arbitration for Sport, but also that you have to appeal to the Court of Arbitration for Sport. I have put here the FIFA rules, for example, which allows you then to go to the Court of Arbitration for Sport. And the statutes do always also say that you are not allowed to go to a state court normally. And that is why everybody is going to the Court of Arbitration for Sport. So now, yes. Now I have talked about the Court of Arbitration for Sport, but how did everything start? And it was Juan Antonio Samaranch who had the idea back in 1983, and it came into force in 1984. So he was the one who was saying we need something harmonized, an arbitration court who is deciding on everything in sport. And they put in place in their statutes a rule which was saying every dispute in connection with the Olympic Games, or in relation, or any dispute in relation to the Olympic Games, has now to go to the Court of Arbitration for Sport. That was the starting point of the Court of Arbitration for Sport. And this was made possible because Chapter 12, as I told you, of the Swiss International Private Law Act is very, very, let's say, easy for arbitration. Switzerland is a very arbitration-friendly place. That's the reason why a lot of arbitration taking place in Switzerland, a part of the Swiss law, which is considered a little bit a neutral law. But it gives a lot of freedom to the arbitrators. If you look at Chapter 12, the state court is eliminated to a limit, because any decision of an arbitration court can be appealed only for very, very, very limited cases. And if we go back in history, since 1984, only 13 or 14 cases from the Court of Arbitration for Sport could be overturned. I could do one, but I did, of course, much more appeals where I was thinking it should have been overturned. But you see, it's very difficult to win in front of the Swiss Federal Supreme Court. But it shows the big, big power that Switzerland gives to an arbitration panel. Now, if we are looking at the IOC, in the beginning, it was IOC financing costs, making the rules. IOC made everything. And this was going on for 10 years, up to the moment of a horse rider, Grundle, who was bringing a case to the Swiss Federal Supreme Court, saying, first of all, it's not a correct arbitration body. It is not okay that IOC is financing everything. She could not win the case, but the case led to some clarification of the Swiss Federal Supreme Court that was saying, yes, the Court of Arbitration for Sport is accepted as an independent sport court, arbitration court, but they were saying, due to the fact that IOC is financing everything and deciding on every rule in costs, this is something that we would not accept as an independent court in case IOC would be a counterpart. But in the Grundle case, IOC was not a counterpart, only a national federation. That's the reason why the Swiss Federal Supreme Court did then not annul the CAS decision. But it led to a change and an introduction of something new, and this was the International Council of Arbitration for Sport. This body is now financed still by IOC and by FIFA and the big federations, and they set all the rules. But CAS is then something, let's say, a little bit different from ICAS. These are two independent bodies in the end. Okay. This is what I told you already. Okay, the new system now, the ICAS is, what are they doing? I will come back to later on it, but who is member of ICAS? It consists of 20 members. 4 members are appointed by International Sport Federation, 4 members appointed by Association of National Olympic Committees, 4 members are appointed by IOC, and 4 members are appointed by the 12 already mentioned, and to safeguard the interests of the athletes, and 4 members appointed by the rest of the 16. So you can see from a point of view of athletes' right, this is of course something which is not a balanced composition, because in the end, even the athletes' representatives are selected by federation representatives. And that makes it quite difficult to have the athlete's voice heard properly in ICAS. But we will see how the power of ICAS is, and it is very important. The ICAS is important. They decide the CAS code. They elect the president and the vice president. They elect the president of the ordinary arbitration division. And what is most important, they elect the president of the appeals arbitration division. And they appoint the CAS general secretary, and they put the persons you have to select from the CAS arbitrators on the list. You have to know that you cannot choose, normally in arbitration, you can choose everybody, every lawyer, or he must not even be a lawyer. You can choose everybody in an arbitration court. But here in the Court of Arbitration for Sport, the idea was to have specialized people deciding cases, and that's the reason why you cannot select everybody, but only, sorry for that, I don't know how to put that away. How is that possible? Huh? Do you know how? You see the rest also, huh?
Thank you for sharing your emails. I think would you go as
okay, now I have it again. Okay,
yes,
sorry for that. Okay, so that's what they do. They have a lot of power, and they decide also about challenges for arbitrators. That's ICAS who decides, not the CAS. Huh? Okay, so, and the CAS, what is doing the CAS? I think the CAS, what we have to discuss here is they make also mediation. They do, they decide also on normal arbitration, but what do? They have arbitration, and there is two different possibilities. You can have a contract between two persons, and they can include the Court of Arbitration for Sport, and then there is no international federation, you go first. So it's an ordinary arbitration, you go to the CAS as a first instance. But this is not so important in CAS. The most important thing is the appeal. That means CAS is there to control a decision of a federation. And that is what the most cases are about. These are appeal cases. Huh? What they also do is they give legal opinions to federations, and they have newly introduced a CAS anti-doping division that is given the opportunity for certain federations who have not the knowledge or not the willingness anymore to deal with these quite complex doping cases. And CAS here would act as a first instance case. In case FINA would have accepted this CAS anti-doping division, it would not be a decision that you had to appeal to CAS from Chinese decision-making body or international decision-making body, but now it would have to, you would have to appeal the CAS anti-doping division to CAS, to the ordinary CAS appeal. Now, then CAS also in certain big tournaments, they do provide for ad hoc divisions where they put in place special rules for Olympic Games, World Cup, and so on, which normally should give the possibility for quick decisions. And these people are on the spot, they are there, and that's the idea behind that, that you do not have to wait for months. So, but you have to have a decision within 24 or 48 hours, whatever it is. Now, As I told you, the most important thing is the appeals arbitration procedure. And what is always important, it needs an arbitration clause. Otherwise, the CAS is not competent. Now, normally, an arbitration clause is put in a contract. In sports, it's not always like that. It's a little bit different because we know the pyramidal structure of sport. On the top, there is always an international federation. Then there is the national federation and the clubs and then the players in the end. But the international federation, they force the national federation to accept their statutes, which includes a commitment to have arbitration, like CAS. And so it goes down to up to the player who has to accept the rules of the club had to accept the rules of the federation, and so on. And that's the reason how all sports athletes have to accept the Court of Arbitration for Sport, especially in disciplinary cases where we can talk about a so-called forced arbitration. So it's not by free will. Normally arbitration is by free will, but not in sports arbitration is it always the case. So then what are the topics CAS can decide on? It can be disciplinary cases, sanctions applied by FIFA, doping is disciplinary, for example, or it can be non-disciplinary, like employment law disputes, where you go first to the FIFA dispute resolution chamber in international dimension cases, and then you can go and bring the case to the Court of Arbitration for Sport. That is something which is not disciplinary, but is dealt with by CAS as well. And of course, most of the cases of CAS are coming from football nowadays. Now, ordinary arbitration proceedings, there are certain rules. You have to make a request for arbitration. That's very similar to normal arbitration. You have to pay the court fees, and I do not mention everything. And then it goes to the other side. They can file an answer. Of course, they have to also appoint an arbitrator from the list. It's a closed list. You cannot choose anyone else who is also specialized in sports law. You have to use somebody from the list. But there are 390 persons on the list, and from from a lot of countries. Now the panel is then appointed, and important is that there will be a hearing, an evidentiary proceeding, as in every arbitration, and we come to the applicable law and the award later on, because we have to focus on the appeal in arbitration proceedings, which is the most common thing in sport. Now here you have also to file a statement of appeal. You have to name your arbitrator. You can choose whether you want to have one arbitrator or whether you have a panel of 3. That's something you can do. And you have to show the Court of Arbitration for Sport why they are competent. That means you need to have a link to a certain arbitration clause or provision in the statutes or in your contract. Then the important thing is you have to file your appeal against a decision of an international federation, which is the last decision in that federation only. You have to do it in a certain time. And to find out which time frame is relevant, you have to go to the federation you are trying to appeal a decision against. And perhaps they have different rules. They can say it can be within 10 days, So in certain cases, for example, UEFA has certain procedure in which you have to make an appeal within 10 days. And if the statutes of the federation are silent, then you have to do it within 21 days. You file your appeal within 21 days. This is not the full motivation of your appeal. It's only the statement of appeal. Then, after you have filed your statement of appeal, you have another 10 days to bring the real motivation. You have to bring all name of witnesses, your experts, and the full reasoning. And here is very important that you do normally have no second chance. That means you have to bring all your witnesses, all your experts, all your full support of factual surroundings in your first application in the appeal brief. Otherwise, it can be too late. Then CAS sends the statement of appeal to the other side, and they have also to elect an arbitrator. And they have then, within 20 days, to find its answer and statement of defense. And you have to bring any defense of lack of jurisdiction as from that point in time. That is quite important if you want to bring the jurisdiction to a problem for the other side. You have to do it in your first application. Then, as I told you, you have to bring everything in your first application. That's due to Rule 56 of the CAS Code. And you are not allowed to supplement your arguments unless, of course, the president of the panel orders differently. Or if the application of the counterside reveals certain things you could not have foreseen, then you could do it. Then what can a CAS panel do? They decide de novo. They have full power of review. That means they put themselves at the place of the federation. So you appeal a FINA decision in our Chinese case, the Junyan case. So CAS is acting as they would be FINA. The decision of FINA does not exist anymore. They come up with a new decision. Of course, they can confirm the decision of the previous instance theoretically, but they come up with something new and they are not bound by the previous decision. And of course, they have the discretion of excluding evidences that you have not brought up in the first instance. So it is very important to try to bring everything what is possible already in a first instance. For example, in the FIFA dispute resolution chamber, there were a lot of clubs that tried to be silent in cases and bring no answer to then start with the fight in the CAS proceedings only. That was the reason why this rule was changed, that somebody cannot be inactive in first instance and then in the second instance with a surprise bring all new evidence. That is something a CAS panel could stop, but it's not clear when they stop it, but they could stop some such behavior. Now, the hearing in CAS, it was never public up to the decision of the Court of Human Rights in Pechstein. I brought a case to the Swiss Federal Supreme Court in the Pechstein case, and I requested that a public hearing must take place, and it was also requested already in CAS, but it was not granted, and in the end, the Court of Human Rights did decide that you have such a right. what is important about this decision in the Pechstein case is that it was clearly said that Article 6 of the Convention of Human Rights is applicable in sports arbitration, which is not the case in commercial arbitration. It was only as of before the Pechstein decision. In commercial arbitration, it is only indirectly applicable, and this is not the case here. And now you have a right to a public hearing that was decided, and you can, of course, you have to request it, and you can bring oral arguments, witnesses, and experts will be heard. Then the most difficult thing in, let's say, in sports arbitration before COS is to find out what kind of law the panel will really apply. And the mess is in here. It's described in this Article 58, which tells you that a lot is possible, but you never know exactly how it will end up. And that is something, but Swiss law at a certain point in time will always come. Then they come the awards. What is interesting here, no dissenting opinion is allowed, which is quite interesting, but not good, I think. For the development of the case law, it should be allowed. And the award shall be made public unless both parties agree. So I think I can stop here. I can also talk a little bit about suspensive effect. What is important to know that if you appeal a decision like in this Chinese case, if you appeal to COS, it's not automatically suspensive effect that is granted. You have to request for such an suspensive effect or for provisional measures. And there you have to prove three things. You have to show to the panel that there is a risk for the athlete of irreparable damage. That is possible theoretically. Then probability of success, you have to show that your case has good chances. And you have to deal with the balance of interests of clean athletes and your client. So you have to find out a way to get this suspensive effect. You can get it. We have seen in the Guerrero case, it was possible. And we have seen it also in the Pechstein case where that was not given, but in front of the Swiss Federal Supreme Court, it was given. So I think that is a little bit about, in a nutshell, about arbitration in Switzerland. And yeah.
Thank you very much, Mr. Valloni. Thank you for this great presentation. We have a very, I have a small question regarding in the history, right? It's difficult to get appeal, but what are the legal ground for those cases has been overturned by the Federal Supreme Court in Switzerland? What are usually these could be the reason?
Well, we have to know the following. There are only very limited grounds, as I told you, and this is like that. I can tell you, it's 5 grounds that are possible. It's wrongful appointment of the arbitral tribunal. That means if they select in the COS case somebody from outside the list, that would be wrongful. Or if the parties agree to having 3 arbitrators and they select only 1 arbitrator, for example. Then this is very seldom. You can forget about that ground. Then incorrect decision on jurisdiction, that is the one that is most successful. Because, I'll tell you why. Because if you appeal on the jurisdictional issue, the Swiss Federal Supreme Court has full discretion on review. And that is the big difference to the other points. Because on the other points, you have to think about, normally a judge can see the whole picture where you see me. But now with the Swiss Federal Supreme Court, in jurisdiction can see the whole picture, quite the whole. But in the other cases, for example, the right to be heard, or the breach of ordre public, or decision made against somebody has not even asked, no party has asked that he should, that the decision shall be like that or that, then you can also go to the Swiss Federal Supreme Court. But the line is only one small line. They can look at the case, and the rest they have to forget, because they are bound by what the arbitration panel has done. And that is what people a little bit forget, that they think that the Swiss Federal Supreme Court has a look at everything. It's not true. You even have to tell our highest court, you see, imagine this, the highest court of Switzerland, you have to even tell them what the law is. What the hell is that? You have to tell them the law is like that. And if you do not that exactly, you have no chance. Which is strange, but yeah. Okay, it's the law. It's the law. So it's very difficult to win. And
we have a Russian colleague.
1%, 1 or 2%.
Yeah, we have a Russian colleague, Ms. Melenikova. Are you there, Ms. Melenikova? That she asked some questions regarding the figures. I'm very curious, you know, from Russian side. I mean, how would you think of the cases or the judgments in last November regarding your country, and how do you think about the case as legal professionals in Russian? Do you think do you have some ideas to share? Are you there?
You're talking about the Russian cases, the different.
Yeah,
Russian
I'm asking Ms. Melenikova whether she can share some ideas from her point of view. Hello, Ms. Melenikova. Hello. Okay, so maybe we will left it later. So, is there any questions regarding Mr. Valloni's presentation? We got one question from Mr. Emily. He asked why the award in Sun Yang did not decide on the witness tampering other than the procedural confidentiality orders in the course of proceeding, which is recurring problems in many cases. First, I'm not quite sure what is the question. Mr. Qureshi, could you explain a little bit more of the question? Wait. I need to. You need to unmute.
He needs to activate his microphone. He has not.
Yes.
Oh, there we go.
Okay.
Sorry.
Okay. Now you are hearing me? No. Hold on.
Yes. Yes.
How about now? You hear me?
Yes.
Okay, you hear me now? Yes?
Yes. Yes.
Okay, so my question is, there have been many instances of witness tampering complained by WADA in the award against the respondent. but I see no pronouncement from the tribunal in the award concerning the issue other than the procedural orders that it had already issued in the procedure, rather than in the award anything to say that. You are not hearing.
To whom is this question?
Yeah, the question I mentioned is with regard to the witness tampering in the case.
Yeah, I'm not a lawyer from from this Chinese. You have to ask the Chinese person.
Yes. Well, okay. Perhaps Mr. Boss could have explained, but apparently he's off now. Yeah. Okay. Thank you.
Mr. Ameli, I think
Yes.
I briefly responded to your question because that's something I'm also very concerned about.
Yes.
So I think maybe the panel already exercised their discretion to draw the adverse inferences. But I wonder, and maybe my learned colleague can also share their insights, whether CAS and under Swiss law, what type of measures they could take to, protect the witnesses or take actions for these matters.
No, you recall in the same provision that of FINA DC that provides for tampering violation of the testing process. Also in the end of the same provision, I guess it's 205, it's talking about witness tampering. And WADA has complained frequently in the case about the witness tampering in the process of the case. And I see no decision by the award concerning it other than the procedural order of confidentiality, which is a completely different thing. I assume that the court should have at least said something more than the procedural orders that had earlier mentioned.
Yeah, I think that we can leave these questions for later, and we can any colleagues, if they read about the judgment, they did not say, the judgment itself did not say anything whether the athletes tampering the witnesses, but it's more about other things. So why this is remain a question? Why the judgment doesn't say that? So
may I say a word on this one? I mean, this tampering, this specific tampering offense is, in my view, a very difficult one because it mixes two things. It mixes the offense which started the process, and then possibly an offense which on its own could be a new offense and actually it should be the basis of new proceedings. And that's a bit the difficulty of this. I think it was put let's say in the first line offenses definition, but it does not really belong to that. And I'm a little bit dubious about the solution of the code in this respect, because this one is an example. I mean, what do you want? Do you restart a case on ADRV based on a violation of the process dealing with another ADRV? And that is why I think the panel cautiously left it out and did not come back. And in my experience, I have had several cases, including this one in first instance, where the issue, and I'm very neutral here, could arise. I have had another one, which was a Croatian case, where they went to the door of the DCO and they knock at his door and tell him that he was wrong. Members of the family and of the entourage of the athlete, and it was relatively scary for the DCO. It's one issue which has to be addressed because DCOs are exposed personnel. I mean, one may think one will, but it's not easy to conduct doping collection process in an environment which may be hostile because it concerns a national hero, for example, or because the people try to intervene with the witnesses. But the difficulty with the 2.5 as it stands now, it really questions whether then you must restart a full first instance proceedings when it happens, actually, because the appeal process cannot extend beyond the scope of the first instance. And the first instance, if you have, for example, witness intimidation in the middle, let's say between the first instance decision and the appeal, which was the case in my Croatian case, by the way, what do? Do you restart a case? The appeal authority cannot start. I mean, CS cannot start by itself a new case. And the other one, let's say the prosecuting authority, in this case FINA, what should they do? It should actually restart, or WADA in this case, they should restart a process on its own merits, if I may say so. Well, voilà. I think it opens the door to very difficult issues. I think it was put there because it was recognized that this may happen, but I'm not sure of the solution to put it in the first line offense. Voilà.
In international arbitration and commercial arbitration, when these things happen, the various measures the arbitral tribunal can take against the respondent if there is evidence of spot. But in this case, perhaps evidence wasn't quite clear. In one of the orders, the tribunal said if it was proven, in the sense that apparently for the tribunal, one of the items of the tampering wasn't quite evident. Thank you.
Thank you very much. Now we have, sorry, we got a little bit delay. We'll have like 20 minutes delay, but I still wish everyone we can have a small break for 5 minutes to have some water, enjoying some snacks, and come back in 5 minutes. If you did not come back, if you are like say sit there, like we can go through with the introduction of yourself. So what I'm going to do during this 5 minutes. You can get some water. I'm here is to read every person's name, and if you would like to introduce yourself, who you are and what you do, and what you're interested to the sports arbitration. If I get no response, I will move on. So now we comes to Mr. Sheng Chang. Could you introduce yourself a bit?
Oh, thank you very much. I'm working at the Beijing Huizheng Law Firm. And advise the clients on international commercial arbitration and mediation. Thank you very much.
Thank you. And the next one is 14-113-434-889. Could you introduce yourself? Sorry, I have to go to this list.
Yeah.
Okay, so next one, Mr. Bo Yi. Mr. Ibo, could you are you there? Could you introduce yourself? Next one is Mr. Florian Müller. Are you there?
Yes, I'm there. Hi, everyone.
Hi.
My name is Florian. Hi, Kenza. My name is Florian Müller. I'm the head China desk of MLL. We're one of the biggest law firms in Switzerland, and we advise Chinese clients in Switzerland and Swiss clients in China. Myself, I'm a Swiss attorney. I have an LLM in Chinese law from Hong Kong University, and I'm a fellow of CARB. So we advise Chinese clients in Switzerland and Swiss clients in China in arbitration matters regularly. Nice to meet you all.
Thank you, Mr. Florian. And next one is Gianmarco Cali.
Yes, hi everyone. I'm Gianmarco Caliri. I'm an associate in Geneva, Switzerland. I'm a Swiss lawyer. I practice in white-collar crime and international commercial arbitration. And I also am a student at the University of Neuchâtel in sports law. Hi, everyone.
Okay. And next one is Mr. Khaled Chaudhary. Sorry for my terrible pronunciation.
Hi, I'm from Bangladesh. I'm practicing in the Supreme Court. I'm a barrister. I'm also a mediator of the ADR International. We train and we also do mediation. I'm also a fellow of the Chartered Institute. So I'm doing a bit of everything. I also run a law college in Bangladesh. We are specializing in University of London and BPP education here in Bangladesh. Sports law is one of my passions. I advise Rangpur Riders, one of the teams in the Bangladesh Premier League. I was also a counsel for the BPL match fixing case defending Mohammad Ashraful and Darren Stephens in Bangladesh in 2013. Sports law is quite still budding in Bangladesh. We need a lot of awareness amongst the sports federations and also amongst the players. Unfortunately, this is not progressing that much. So I think this kind of interaction would be a great boost for me for the future. So I'd like to work with all of you in the future. Thank you very much.
Thank you, Mr. Karat. Thank you for joining us. And the next one is Mr. Jingwen Feng. Sorry. Could you introduce yourself? A nice background, by the way.
Yes. Nice to meet you guys. I'm very happy to join this great event. My name is Jingwen Feng. I also from Beijing, from Anjie Law Firm. You know, my specialty is basically intellectual property rights, as well as entertainment and sports law. And I'm also the member of FISU Legal Committee, newly appointed. So it's very happy to join this event, and I would like to communicate with you guys to discuss about this sports law, mainly on the孙杨case. I think we'll have a lot of fun here. Thank you.
Thank you very much. And the next one, Mr. Raffel. Raffel, are you there?
Yeah, hello everybody. My name is Rafael. For those who haven't seen me in the last webinar, I'm originally from Zurich, Switzerland, and I'm living in China for about 2 years. I'm based in Chongqing, and I'm the incoming office manager for the Bedin & Lee LLP, which is a Hong Kong-based law firm. And I'm a greenhorn in sports law, so I already learned a lot today. Thanks a lot for that.
Thank you very everyone. I hope everyone is coming back. We'll do the rest a little bit in a later stage and in the last part. I hope everyone is there and have had a great water, enjoying the break. And so it is great. Like when we have this kind of discussions, we have lawyers, but in the sports law, we need to. It's essential to bring the professionals. I mean, the athletes joining with us as well. So that's why. It's my great honor to invite Mr. Zhang Ping, who was a gold medal winner in the 2004 Summer Olympic Games, to give us a discussion regarding her perspective, or like an athletic perspective, a personal perspective of anti-doping. And Ms. Zhang Ping is a renowned former professional athlete in China national volleyball team as a middle blocker. And he's the golden generation member. She is a gold medal winner in the 2004 Summer Olympic Games in Athens. During her professional career, she led the team to win 2003 Asian Volleyball Championship, 2006 Asian Game, 2003 FIVB Volleyball World Cup, etc. Currently, she is a lecturer in the Chinese University of Hong Kong. So, Mr. Zhang, and the floor is yours.
Hello, everyone. Hello. Hello, can you hear me? Okay. So now I open my PowerPoint. Yay. Okay. Hello, everyone. I'm delighted to be here and have this opportunity to share something with many outstanding lawyers around the world. Today, my topic is an personal perspective of anti-doping. So this is my presentation content. I'm going to talk about doping in sport and World Anti-Doping Agency, WADA, and a high performance team in sport. So the first one I want to talk about, as stimulate are drugs that usually cut on the central nervous system to modulate mental function and behavior, increase an individual's sense of excitement, and decrease the sensation of fatigue. It's usually for increased muscle power or endurance, such as sprints in track and field or marathon and so on. But different sports need different physical condition. For the weightlifting, if two athletes in 50 kilogram division, both having 100 kilogram, then the one who weight less will be the champion. So diuretics or water pill, which help the kidneys flush extra water, metabolic product of the drug, and the east side effects from body and decrease body weight. And for another one about shooting, golf, and archery, other kind of stimulate depressant that can help players stay in the extreme hip climb, stability, and quiet level. My friend told me a perfect and stable timing for shooting is between heartbeats. So as technology advanced, the doping to clearness increase. There are about 9 kind of substance of stimulate. Next, I want to talk about the WADA. I say the reason for the ban are mainly the health risks of performance-enhancing drugs and the equally of opportunity for athletes and the exemplary effect of drug-free sport for the public. The WADA was set up in 1999. So it is to fight about against drug in the sport. Before 2005, I attended all of the doping checks was in of competition simple collection. I remember when I finished from a day and match, the doping control officer, DCO, find our team doctor and the credential for all players and then did lucky draw process. Because volleyball is a team sport, the DCO only choose one player to attend doping check. I was a lucky one chosen by the DCO. The DCO lead me and went to a room with a toilet. And then she showed me the collection equipment. After that, we went to the toilet together. She looked at me finish my urine collection in a disposable cup and verified it is my body fluid. And then I put my urine sample to the right A and the blue B bottom respectively and close tightly. And then put the box in the white box and seal it. Finally, I set in a document, the doping check simple collection finished. So the World Anti-Doping Agency's mission is to lead a collaborative worldwide movement for doping-free sport, whether in or out of competition, using performance-enhanced drugs goes against the spring of the sport. So Anti-Doping Administration Management System, ADAMS, was launched in 2005 for the initial blind freeze. The system has since then been introduced and implemented by most anti-doping organizations, ADAMS, and all WADA accelerated anti-doping laboratories. The web-based functionality show athletes to comply with the whereabouts of their sport by entering their information from anywhere in the world. This is the diagram to show us this whereabouts module in use. The color of the gray and the orange is for residents. Fill in your overnight accommodation. The blue one is for traveling, that is including routine number, departure location, arrival location, date, time, and details like returning from match. And the gray is for competition. The yellow is for your regular activities, such as your training, your work schedule. And according to this calendar that from all elite athletes around the world, the ADAMS doping control database provided to ADAMS in an essential tool to managing both in and out of competition doping control program. Okay, this is the picture to show us the simple collection equipment. And this is the document which I found from FINA website. I think this is the humanization design statement for freshmen to upgrade to comfort of operation for wearable module. FINA doping control rules opposed by the FINA Congress on 29 November 2014. This is a statement about whereabouts failures of anti-doping rules violations. Any combinations of three missed tests and or failing failures as defined in an international standard for testing and investigation within 12 months provided by an athlete in a registered testing pool. Next, I want to talk about a high performance team in sport. For my opinion, there are three members around athletes should include the coach, the team doctor, and team leader at least. For daily training, that include exercise content, intensity, timing, how to use strategy and statistics in match, comply with the coach. For medical part, involved nutrition intake, athletic rehabilitation, body check, and doping check, submit to the team doctor. For transmit the policy, social part, and the daily arrangement like endorsement and advertising and so on, obey on the team leader. There are three persons to help athletes focus on training and competitions. I hope one day a lawyer can enjoy the team who can perfect in the West and the East legislation, understanding the legal and the court procedure, design a training program of multi-court, and finding out the compelling evidence that can safeguard athletes' interests and also to help them to get more competitions. That is all of my competition. Thanks for listening. Thank you all.
Thank you very much, Mr. John. I'd like to ask if there are any questions for Mr. John, and besides the signatures and photos. It's as athletes, I have a question like if how do you think if you have some legal problems, if you have some problems as a Chinese athlete, who are you going to call for help? Do you have a lawyer? Do you have some people to offer help?
I don't have any personal lawyer. I said we have the team leader. The team leader will help all the athletes to deal with some documents, some the legal fees, and to represent our maybe sign in some documents. We don't know. We don't actually know the detail. I mean,
Yeah, how about in other countries? For example, let's say in Bangladesh. So, Mr. Khaled, how about in your country? Like, do you athletes has a lawyer, or how does it work?
Okay, sorry. It's unfortunate because unless someone is in trouble, I mean, people do not actually go to a lawyer. So as a general rule, I would say even we've got highly paid stars like in cricket, like Saqib Al Hasan, Mushfiqur Rahim, and even they do not really have a lawyer, as far as I know. When I advised them as a team, I found that was wanting, and that is why I stress on the point that more sort of awareness building workshops should be organized. And many of the athletes are not really, I'm very sorry to say, not into education and stuff. So they need maybe even translated version of the law in Bengali. It's my first language. So in that way, yeah, I mean, taking help of a lawyer is like is a last option. But if it could be done in a more systematic way, in that way, I think players would be better advised. We also do not have sports agents, for example, so that the interests of the players are not really very well looked after. Yeah. Thank
Great. How about in Switzerland? In Switzerland, does athletes have a lawyer or like a legal team to consult? I mean, how does it work, Mr. Boss?
Don't really know where they're going, and they're just following the instructions of, for example, the Swiss Olympic Committee, for example, who provides them some guidance, or any other Swiss anti-doping agency. But often those athletes that I've known, maybe not the top athletes being taken apart. I'm sure Roger Federer is well advised, but most of them don't really know. And for example, taking not really on the legal point of view, but on the medical point of view, they're pretty much or often left alone as regards the medication, the drugs, how they affect themselves, and to properly understand the prohibited list of WADA is quite a challenge for them.
Okay, thank you. I think this question is particularly interesting. And how about in Hong Kong? So, Mr. Sun, Seto Wai-sun, how about in Hong Kong? How does it work?
Well, I'm not actually in the area, so I'm not sure I could usefully contribute to the discussion. But surely, I think the rules itself. I think as China is getting actually more actively in the international arena, I think making those rules and how China should participate, how it could more actively participate in making those rules and in actually handling those arbitrations, I think should give us more food for thought.
Thank you very much. So, so we don't have much time left, but we will continue. We will maybe have 20-30 minutes for a little bit later. So, just so next, please allow me to welcome one of the earliest person who participated in the sports arbitration from 1988, where the CAS established, Mr. Jean-Pierre Morand. He's going to discussing about non-analytical anti-doping rule violations. So Mr. Jean-Pierre Morand specialized in corporate and sports law. He acts as a counsel for International Sports Federation, which is the Olympic Committee IOC, and major events organizers. His services regularly required in international arbitration proceedings, including before the Court of Arbitration for Sport, CAS. He has served in Baker McKenzie, New York, and Geneva, IMG as a lawyer and a counsel. He is currently a partner at Cajas in Lausanne. And we also made a video interview regarding in Jean-Pierre Morand. Particularly, I found it's difficult to pronounce the law firm he is currently working on, and maybe he can start by sharing how does the law firm pronounced. Thank you very much, and floor is yours, Mr. Zhang.
Okay, I'm trying to share my screen. Is it done, or is it? Do you see it, or how do you see? It's okay. So well, I am effectively I have been active in sports law since now I'm getting old, 30 years, and I started by mere chance being an associate at Baker McKenzie Geneva, serving a client, which then asked me to join as a legal director and then associate operational director for 5 years. It was Mark Beaver Development, and then it became IMG Switzerland. It was bought by IMG Switzerland. And then I went back to private practice, and then I pretty much specialized in both sponsoring first, and then I was heavily, I used the Court of Arbitration for Sport, I think, as the first one to arbitrate non-technical sports matters, including sponsoring contract, because I found it was at the time a very handy and economical way of handling, let's say, sports-related commercial matters, because that was my main interest at that time. And then I moved and I became highly specialized in doping, especially in very technical cases where I supported. Then I was completely on the institutional side from the start of my career. I mean, the life chose for me, and I was on this side of the fence. And I specialized in notably highly technical cases. And then I ended up, I mean, the last, my last years have been haunted by the Russian cases, which I handled on behalf of the IOC. And in FINA also I have a 25 years career as the, let's say, reference counsel for FINA in all doping matters, which brought me in the Sun Yang case on first instance, and then I left the case for conflict of interest matters. And that is why I will be very reserved on appreciation of the case itself, but it doesn't prevent me to give some general opinion. So I also served 20 years as an arbitrator at the CAS. And then I quit when it became impossible to be both counsel and an arbitrator in 2009. But I was also one of the co-writer of the rules of the original actual rules, which were actually established in '94 and then several times amended, but the basis was established then in a redaction committee to which I belong. So I mean, to make a long story short, I mean, sports law became my legal life for 30 years. I'm not sure I would have chosen that, but it was chosen for me, and it ended up like this. Voilà. I mean, I don't want to be long on the. I thought we would have a five minutes presentation and then have a discussion. So I mean, I chose to have a very specific topic, because otherwise it would be too long. And I chose the one which I think had some importance in this case, because it also touches on the evidence rules, and it's the difference between so-called analytical and non-analytical violation. I mean, the typical analytical violation is really the presence of prohibited substance according to 2.1 WADA code, and then you have, of course, the implementation in this case in the doping control rules. Here, I would just like to mention that there is a certain amount of unclarity about the application of the WADA code, because very often it is meant as if the code would directly apply. Technically, normally it's not the case, and Mr. Boss aptly described it. The applicable rules are the FINA doping control rules. However, they implement within FINA which has the obligation as a signatory of the code to do that, they implement at FINA's level the content of the code. So I mean, there is a, let's say 90% of the code becomes effectively the rules applied by all sports federations. And this includes one of the questions you mentioned, that is the use of the CAS. The use of the CAS as an appeal, as the appeal entity is compulsory. That is, there is no alternative for international doping cases, at least. They all have to, if they are appealed, end up in front of the CAS and nowhere else. One may discuss whether this is very difficult, this is good or right. I just want to mention one thing. The CS is certainly not an ideal solution. The question is whether it is an ideal solution, is whether there could be a better one. And there I have my doubts, because it's not easy to have, it's necessary to have a kind of unified solution with a certain, not complete coherence in the decision. And in this respect, this brings me to the idea that the fact that first, you have to go to the CAS and not to national court. I think for me, it's the only solution, because we see, and I have seen that in my practice, with all due respect, national courts, quite apart from having probably different legal approach, will have different concept of protecting or not protecting their own athletes. And this was, I mean, the Puerto case is a good case. It was, I mean, the door to access the evidence in the Puerto case was closed and then open, was closed by the courts protecting their own athlete, then slightly opened by one judge and then reclosed thereafter, and then reopened in the end when it served no purpose. So, you know, national courts are not the appropriate jurisdiction to deal with international sport, because there are too many competition between the, unfortunately, personally I think it's wrong, but I mean, there are too many national issues behind sport to let the decision at national level. So the concept of an, let's say, neutral international court having jurisdiction, and there the Swiss law is offering some options and possibilities which one can find too broad or too narrow, whatever. But I mean, it's a possibility, and I think I struggled to think of a better one. Now, there are certainly improvements which can be made in the CS still, but the concept of having a completely open list is probably not a good one either, because again, you need to have a certain unity of doctrine. Then how the potential athlete representative are chosen is another matter. It could be addressed and worked on. The problem with the athlete is to find who are the representative of the athletes, and who will be the ones who elect the athlete's representative in a way which represents not only the athlete which are concerned by anti-doping, but the ones which are very often sometimes forgotten in proceedings, is all the others. Because it's very nice to protect the athlete's rights, but the athlete's rights include the right to compete in a, as much as possible, doping-free environment. And what I have seen in my experience, by the way, is that very often when you speak with athletes, they are more, let's put it that way, strict than we are in considering the consequences of doping. And they, I mean, in the Russian case, it was almost, it was very obvious, and I think sometimes even went too far, but the athletes wanted to have the Russian athletes being kicked out because they felt they are not competed under fair condition. And I'm not commenting on that, but it's a fact. The more strict, the call for the strictest actions came from the athletes, and even to the extent that it pushed the IOC to things which would not have been absolutely necessary, like applying to the Supreme Court, whilst there was obviously, when you think of the ground, very, 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 very low chances to have a reversal of the decision which were favorable to the Russian athletes. So voila, that's just a general policy comment. Now, I mean, just to the team, and I just want to the topic I wanted to address very quickly. I mean, you have the technical doping violation, and effectively, what I have to say is that the whole system is more or less conceived with this principle definition of the anti-doping violation in mind, which makes it sometimes very difficult to, I mean, more difficult to handle non-analytical cases. And why so? Maybe just a comment. I mean, sometimes it is said, okay, the rule of evidence are very tough on athletes, which is correct. The problem is that if you want to involve in the rule of evidence as they stand, something which would go beyond let's say, the evidence of an objective fact, which is, for example, the presence or not the presence in a doping sample, it becomes very, very difficult for private organizations, be them as powerful as they are, to get to the evidence. And as a basic rule, we'll just come back to the evidence rules before, but I mean, at the beginning, I mean, the words in dubio pro reo was coming back, but if you would apply that and apply it to the intent, for example, then it would be impossible for a non-state authority to get to any meaningful result in the anti-doping fight. So there is, that is why, and sometimes it's miscommunicated also, the anti-doping rule system is based on the duty of the athletes to prevent any elements linked with doping, meaning any trace of a doping substance to enter their body. And this puts an heavy, I do realize, a very heavy duty on the athletes, but it's the only way it can work. Otherwise, because you will never know, or let's put it better that way. It depends. If you have EPO, then there is no sensible reason why you would find EPO in an athlete body. But with almost all the other substances, you would have possibility of explanations, starting with contamination, which could explain that you detect a substance in a sample. And you can never draw any conclusion from a punctual analytical result, because it can be either contamination, for example, to address that example, or it could be the end of the excretion curve. So, I mean, for example, the quantity found in the sample is absolutely meaningless because you are just testing at one time. Voila. Sorry, I mean, I've been going away from my sample. So just to address, we have the analytical ADRVs, we have the non-analytical ADRVs, and there I have done a second distinction, because you have the nearly analytical ADRVs in 2.2, which instead of presence of the substance, which is established by an analytical process, goes on use. But sometimes, since this 2.2 WADA code covers the methods and not the use, for example, EPO is considered as a method, and it's still based on the analytical basis. The 2.2 is also applicable to the athlete biological passport. And here again, it's partly an analytical and partly let's say an expert-based evaluation, which concludes that a violation was established or not. So we are still at the limit of an analytical cases. But then 2.2 also include typically non-analytical violation. And one of them, in my view, quite strangely, because I never understood why they put some part of tampering on the 2.2 via the prohibited list M2, which lists tampering, adulteration of the samples under 2.2 WADA code and not 2.5 WADA code. I don't know exactly why this was done. I could never obtain a clear explanation, but that's it. For example, the adulteration of samples, typically for example, the substitution of urine in the sample which occurred in the Russian case would fall rather under 2.2 more than under 2.5. And then you have the, let's say, the clearly non-analytical idea of these, and 2.3, 2.4, 2.5, I think we heard the whereabouts failures, which were explained. Then you have the refusal or the evading, and this is the typical, the one which is which is in the center of the Sun Yang matter, with 2.5, which is also obstruction of the collection process when they do not fall under 2.2. And we have noted in that 2.5 covers witness intimidation. I have said what I saw, that it was a difficult one because typically I'm not sure whether it could be handled by the decision-making authorities, especially at appeal level, or if this should not, when established, lead to a separate and independent anti-doping rule violation proceedings, with also the possibilities that it would mean that it would be already a multiple violation. And this is a question which remains unanswered, and I think it probably will remain unanswered for quite a while. Then you have let's say the circumstantial violation, possession, trafficking, administration of prohibited substance. This concern more, let's say, normally not the athlete. Also, an athlete can be also an administrator in that sense. Complicity with a very, very wide interpretation of complicity in one of the first case, which involved which occurred at the Olympic Games in 2006 in Torino, if you remember. So they applied complicity against all the athletes for the violation committed by the other, which I found a very, very broad interpretation, and it was not followed in the Russian case, by the way. And then forbidden association is when an athlete associates with medical personnel supporting, which it's the Puerto environment, if you want. If we go to and again, very quickly, the difference, I think one major difference between the analytical and, let's say, broadly speaking, non-analytical cases is the evidence. And just to remind you that the general rule of evidence is that the basis of the IDRV must be established to the so-called comfortable satisfaction of the panel, which is something in between a classical civil law standard, which is balance of probability. So if you have two solutions, the ones which marginally appears as more probable would be chosen. Comfortable satisfaction implies that the panel must have a certain level of comfort in reaching that solution. exactly what it means, I mean, in practice, frankly, it's a very tough question, because in the end, this addresses the conviction of the panel, and if they are it's a problem. I mean, it's a problem to draw a distinction, and if you go, oh, I lost my, let me, voilà, sorry, I lost my, I don't know what happens here. Anyway, I lost my presentation, so I don't see it anymore. Let me
think
see.
you can click more once. Click more to the. There is
Voilà. Okay. Sorry, and I am not yet a specialist. One important aspect here is that an important difference is that the analytical aspects, which are mainly the aspects which are handled by the laboratory, are covered by a presumption in favor of the elements, let's say, covered by the laboratory process and the analysis. When you moved on a non-analytical case, this becomes irrelevant because you are not in the laboratory precisely, and therefore there is no strong presumption for non-analytical aspects. And one aspect which I think is a particular one is effectively in certain environment, and this was very strong in Russia, and pardon to my Chinese colleague, but it was also relevant in this Chinese environment, because there was very high level discontent about the fact that Sun Yang was implicated, and for a Chinese citizen to come forth and to testify against the national hero is something which is not necessarily easy, and there was no, to my understanding, there was no available direct evidence of pressure, but you just put you in the shoes of a DCO who has to say, my witness statement is maybe going to send out Mr. Yang for 8 years. Voilà. I mean, and then it raises the question which was addressed by the panel in a rather differentiated manner of the protection of the witnesses which were willing to come forward, because the arbitration court has no power to order. I mean, if somebody doesn't want to come, it doesn't come. And in this case, I think, I'm not quite sure because I did not reread recently I mean, I know what happened in first instance. We had only one witness coming forth out of 3. So, voilà. But that, and in particular in the rules, there was no preference to the DCO witness statement. What is very important is, let's say in the process, when something goes wrong, I think the lesson to be learned is that you must document what happens contemporaneously. And here we had some contemporaneous evidence, but I think the stronger evidence will be contemporaneous report, communication, which translate what was going on. And this was important in this case. Voilà, so in terms of evidence, the result is that based on the rules, there is no specific added value to the DCO witness statement, except that, of course, as they are, especially they are not assermented what we say. So I mean, they, formally speaking, they have no more values than the, let's say, athlete's entourage. But as I experienced, and I mentioned this Croatian case, I mean, the athlete's entourage has the tendency to bring any supportive witness statement they can, and so it's difficult because I mean it's up to the panel to evaluate the evidence, and this is a principle under Swiss law, and then it depends on the circumstances of the case. Another distinction between analytical and non-analytical, and I will stop with that, is that when you start in an analytical case, you always are linked with the collection process. So it clearly says who is in charge, because in this case, FINA ordered the collection. So FINA has the result management jurisdiction. In non-analytical cases, also in this environment, Sun Yang, it was also clear because it was again FINA. Clearly, sometimes it's not so clear, and I can cite an example is the Thai girl who made confessions on TV that she had been doping during a period covering notably the Olympic Games, but not only. And in these cases, it's more difficult to say who is in charge. And the code solution at this stage is a very formal one. It says the first ADO, for me, implicitly, who has a connection with the case, who starts the process, has the jurisdiction to conduct the proceedings. Voilà. And this was, I mean, I don't want to go further on my topic because already I spoke too long, having expanded on other matters. But I think it's better now if we can have a discussion. Otherwise, we will exhaust the time by ex cathedra. Voilà.
Thank you very much, Mr. Jean. And it's a great perspective regarding the analytical and non-analytical. Maybe for the Chinese lawyers, they're not very familiar how to define the analytical and the non-analytical. Can you provide a brief definition? And also, in the Sun Yang's case, or in the non-analytical cases, the threshold of evidence should be lower than the analytical cases. Is that right, or there are some general exceptions to that?
I didn't say. I mean, first of all, analytical is really when your violation is defined as being the result of an analysis of a sample. For example, you find the solution, and stricto sensu, it's only for prohibited substance under 2.1. In a more extensive manner, it's also for EPO cases, ABP cases, because also there it's for the EPO clearly an analytical result, and for the APB an analytical results interpreted by expert panel, but it refers to, let's say, an objective result, and you say, okay, this result is what it is, and it's on this result that we are basing the violation. Non-analytical cases are based on behavioral elements, like not collaborating to the process, obstructing the process, keeping prohibited substance in your storage room, etc., or in your car, etc., or administrating prohibited substance, but it does not depend on an analytical laboratory result, if you want. That's what I would, how I would define it. And I mean, there is no, as a matter of fact, I mean, the burden of proof is exactly the same, except that for the analytical content, you have a presumption which does not apply for a validity, which does not apply for the other elements. For the other elements, you just work with the general rules. You have to be satisfied that it occurred, and then comfortably satisfied. And then, in theory, I mean, the athlete could come with a slightly lower threshold and say, because of this element that I am now establishing at a slightly lower threshold of burden of proof. But again, I mean, what does it mean? I'm not sure. I have been an arbitrator myself, and during 20 years, but I'm not sure how I would do the exact distinction of this difference between comfortable satisfaction and balance of probability. Also, technically it exists, but in reality, I'm not so sure. Then, voila, that's the way but it's the same evidence basic rule without the presumption. Voilà.
I think Mr. Lucien has a question.
May I say something? May I say something to that? I remember the Verpalou case where we were acting and we could win the case. The Verpolu case, there was no doping substance found in the body. It was about blood values. And there we could convince the panel that there must be 99.9 satisfaction, 99.9 proof that he has doped. You see, it is not a positive test. As long there is no positive test, the burden of proof must be as high as possible. It's the same, it must be the same burden of proof if they say you are the father of this child. In the beginning, when there was no DNA test, which is now very, very clear, it had to be always 99.9%. And it is not, it should be the same here, and it was the same in the Verpolu case. So I think there is a difference, and there must be a difference.
I would politely disagree, because I mean, there are also, the Verpolu cases is what it is, and congratulations to Mr. Balloni, but I am not sure it will serve as precedent for the end of times. The 99.9% is certainly not something which I have ever seen taken back. I mean, there are also precedents where panels have said, I've referred to in dubio pro reo, they were contradicted by further panel. In this respect, and without, I think we won't go in that discussion, because it's but it is clear that you must never forget that a decision by one panel is a decision by the CAS nominally, but in the end, it's a one panel decision. And that's a little bit ambiguous in the CAS, because there are no absolute precedent value in one decision. And there is no, let's say, temporal time higher value of the first, let's say, panel who decides something, and then this would prevent other panel to have a slightly different view. And again, without entering any polemic on this one, I think you have to realize that going forward, panels of the CAS may differ to precedents, but must not differ to precedent of the CAS. And it's something which there is a tendency to observe precedents, but in a system of arbitration, which I would describe as being horizontal and not having a Supreme Court on top, which would say what is the leading precedent, there is still a moving ground between one decision which exists and then the next one. It can go, Mr. Balloni, it can go both ways. I mean, I assume, but there is no absolute precedential value in one panel's decision.
Thank you very much, Mr. Balloni and Mr. Zhang. For me, I'm not familiar with the case. If you can type what is the case about and about the reference, so we can do some homework afterwards. So that will be really really helpful. And so the last lecture we have one. We discussed a lot about sports arbitration so far, and now we can relaxing a little bit, discovering the collaboration opportunities between Swiss and Chinese lawyers and future collaborations, particularly in Shanghai Free Trade Zone. So let me welcome Mr. Ye Fang. As you may, she is a senior partner of Albright Law Office. She is a PhD in law and a senior partner of Albright Law Offices. Her practice area including cross-border investment, financing, merger and acquisition, dispute resolution, real estate infrastructure, and free trade zone legal services. Mr. Ye has provided legal services for a number of banks, including a lot of famous clients around the globe. So time is yours, Mr. Ye, and I hope we can you have 15 minutes.
Thank you. I'm very pleased to be the last speaker. Can you hear me? Okay. Yeah. Yes, we are talking. We have talked about sports law and case Shenyang for a long time. So I will have a brief introduction for Shanghai Free Trade Zone and the legal collaboration here, and that's our future opportunity to cooperate as legal providers. The contents will be including the 3 parts. So when I attend the International Bar Association annual meeting, I met a lot of international professionals. I was always asked by 2 questions. Oh, you're counsel of Free Trade Zone? The first question frequently asked is that free? Okay, the second question usually is, what's the legal infrastructure there? So I think that will really influence our legal service here. And China is a faster changing society, including the legal service industry. Some of you might know the Free Trade Zones launched in September, the end of September 2013. And many people will ask why China started doing that. So many years later, people starting to know it's not another high-tech park, another industry park, not anymore. They are doing something new, experiment. Yeah, it's a kind of lab of reform. That's China usually to do. In like the Shenzhen, it's a lab for the national reform. Then it will copy it to other places. So at that time, people say that's the 4th wave of China economy. The first wave is the 40 years ago, China open and reform policy. The second economic wave is 30 years ago. It's Shanghai Pudong new area. It's the whole land here. Development. That's where we are. And our office here. The third wave is China joined WTO in 2001. And the Free Trade Zone policy, along with the One Belt, One Road policy together will be the 4th wave. Okay, yes, starting from that year, you can see the doing business of the world, ranking by the World Bank annual report. China ranked starting from 96 until now it's 31. And Shanghai and Beijing, 2 cities, became the 2 weight in this ranking. And there are many index here. And I would like to show the index mostly related to regulations and laws. That's smart governance, SMART. So I like that. That's very organized to describe our reform vision of China governance. Okay, so in the past 7 years, China Free Trade Zone expanded to different cities or province. So we have different colors here, starting from the red to the green, then yellow area, then the orange area, Hainan Free Trade Island. Okay, even in Shanghai municipal city, we spent from the the first part into another 2.0 to 3.0 version. Included some pre-existing industry of Zhangjiang high-tech industry, Lujiazui financial area, Zhangjiang high-tech industry park, and the Jinqiao export industry park. Okay, so now we are here. Last year, we start launching the new area of Shanghai Free Trade Zone. You can see the blue line. The blue line is a river. The north river named Dazhi River. The western river is Jinhuigang River. So why Shanghai use this two river as the border of new area? Because Shanghai wanna enjoy the Hainan island policy. So he has to make two rivers as border. So make it looks like an island. So you can try some more profitable policies and reform here. Okay. So in this area, the vision of this area for the future 15 years or 16 years, that will be 2035. Till that year, the goal of this area, the GDP, will want us meet the 1 trillion. 1 trillion RMB. That equals half Singapore RMB GDP, and the entire GDP of current Pudong area. So the vision of this new land is to create a new Pudong area, and the population there is now currently the population is 690,000 population, and the future 15 to 16 years, that will meet 2,500,000. Okay, so you may know some of the projects here already, like Tesla new manufacturer already built, complete the build and the cars sold. And you may know a lot of news of Tesla here. Okay, so yeah, that's something related to the arbitration business. So before this, the Shanghai Free Trade Zone new area, there are already some famous arbitration center already set up their rep office here in the prior policy of free trade zone, but now they can set up their not only rep office, but also the organization, the operation office here. That means it can not only to do some liaison works, but also to do their business here. And even more, starting from January 1st this year, 2020, the Shanghai measures is active now. So the list of applications not released now, but I can imagine there are some of applicants already, and we will know the news soon. Okay, oh, that's the application process. Yeah, so we welcome more and more famous pre-existing arbitration institute setting up their business here. That will help Free Trade Zone to join the international society. Okay, it's also the application process. Okay, that's the case, Shanghai. Yeah, I think you already know there are 6 cases heard here. So I just put the information for you. And one of our Albright's formal partner, Mr. Professor, we call him Professor Chen. He is a professor and also a senior partner here, but several years later, several years ago, he retired. He used to be the arbitrator of Shanghai case. Okay, so we do have some policies here in free trade zone, the new area and the pre-existing area of foreign law firms and local Chinese law firms association. And we, I post like 7 association cases here already. See, Beckman can see Hogan Lovers, Esther, Linklater, very many big name here. And some of them, they associated with a smaller, very small law firm. They have already established cooperation before. And some of the local firm, it's not small, they're very big, such as the number 2 in Thai law firm. It's in Shanghai, it's specializing in shipping area. And the third, it's a Fujian Fidelity law firm. It's the biggest law firm in Fujian province. And the 4th one, the Guantao law firm, is very big, national firm, many branch offices in China. And our firm, Albright, we are also thinking about such kind of association with our strategic partnership law firm, that's Bird & Bird, a British law firm. Okay. Oh. Next slide. Oh, yes. Yeah. We recently visited the new free trade zone area, the administration office, and it's our delegation visiting. We are talking about is there any some new policies in this area for the legal service cooperation. Okay. Okay, thank you. Do you have any questions for me? Hello?
I mean, yes, I have, Jean-Pierre, I have a question for you. There are 2, I mean, here I'm putting my hat as a Swiss Arbitration Association board member. And I consider the following proposition. I mean, we are, I mean, in our association, we are discussing international issues. And now China, and we in our narrow sports discussion, we mentioned that sometimes there is an imbalance of the rules geared towards, let's say, the white community. And I think in international issues, there is, I mean, the most applied rules are normally the Anglo-Saxon rules and the English law, etc. And this creates, let's say, I am not a fan of saying that the law is geared to one party, because normally the law is something which is neutral. But in the perception, I thought that Switzerland with Swiss law could have maybe a role to play in offering a more balanced solution, alternative solution for the Chinese parties especially. Because first, it's a civil law, and I understand you are a civil law system. So maybe from the perspective of understanding the system, it's easier from a Chinese lawyer to let's say, to associate with the the functioning of a civil law system like Switzerland. And secondly, because let's say the commercial elements of Swiss law are very stable. I mean, our code of obligation is a very old law which has not moved which is not moving every day, unlike certain laws, and especially also laws which are strongly based on precedent. But if I take another law like French law, where they do a law for any possible issue, so it's a very difficult environment to comprehend, to understand. And I thought that Swiss law could be an offer for, let's say, building up a basis on which Chinese versus other international parties could be more at ease to proceed than just applying the Anglo-Saxon standards, where only the Anglo-Saxon, let's say, firms are at ease. And in this respect, I was very interested by your presentation. I was wondering suddenly whether the chambers of commerce were administrating the Swiss rules, but more fundamentally maybe the association, a body like the Swiss Arbitration Association, could maybe develop concretely such an offering on site in your free zone areas. Because how would it be perceived from China? Sorry, it's a long question. Voilà.
Yeah, I think your question is related to my first. I first mentioned I was frequently asked two questions. The first one is it free, or the second one is what's the legal infrastructure? I think we really think about in the new free trade zone here, because compared with like Dubai, Kazakhstan, Qatar, and now even Kazakhstan, they are establishing their free trade zone based on common law system, not their own law, not the local law. They establish their court and the entire system based on common law. So we are looking for this, how they works there in that free trade zone, how it helped the major player play. But you know, in Chinese history, we have some bad feelings about foreign law application, especially in the Opium age, Opium War age. Shanghai has the foreign jurisdiction territorial. That will make our government nervous. So I think you really raise an alternative resolution that is Switzerland law application. Yeah, I think we are doing it because I used to be a teacher of a party school named China Executive Leadership Academy. It's a national officials training school. At that time, I was selected by the central government, trained in Switzerland, you know, at that time, 2006, 14 years ago. We are trained by most of them. It's a US-based human resource theory and textbooks sometimes. But at that time, I think about this because Switzerland is a neutral country, so that help our two systems to trust each other. And here we are doing some research for Shanghai court system, to how to try to see how can we reform, to formulate a new kind of legal infrastructure in new area of new free trade zone. So I really think you need come to talk about your idea to our decision makers, lawmakers, And this area has their own power of lawmaker from central government. Yeah.
Thank you very much, Ms. Amy. Is there any questions? If not, then I would like to present of Swiss Chinese Law Association. I firstly would like to thank you for your time here. I know some colleagues, because of time, they wrote to me that they cannot participate because we delayed. So we'll share the videos to with all the colleagues and also the PowerPoint to all the colleagues, because who registered this conference. And secondly, which is most importantly, I wish you and your family stay in health. And it's a difficult time, and it is important to wear a mask. I mean, I personally don't agree with the CDC, and in China and Hong Kong SAR and Singapore, all the guidelines were about wearing a mask. I mean, wearing a mask really protective of the issues of the coronavirus. And thirdly, it's like I have to apologize for those people we don't have time to introduce yourself, and but you have the email address of every person, so you're welcome to send some images and emails, coordinations, and introductions, whatever you found interesting to other colleagues. I guess most of the colleagues are at home and like me, so we would love to read some your feedback, emails, whatever. And more importantly, we as a tradition, what we do is we have come up with a report of this meeting. And I urge, if you can, write a brief summary of what do you think this case is, what do you like, which part would you like to be particularly mentioned, so we can contribute this report as to share for all the colleagues, because we can continue this discussion not only with this 3 hours meeting. So that is all, and thank you all, thank you for you all, and wish you and your family great health.
Bye.
Thank you.
Bye. Thank you.
Bye. Thank you.
Bye.
Bye. Keep in touch.
Bye.
Bye.
Thank you.
Bye-bye. Thank you.
Bye-bye.
Bye-bye. Bye-bye.
Bye-bye. Bye-bye. Bye, everyone.
Bye, everyone.
Bye.